You know, I've been sitting on this for a few days now, trying to let the dust settle, trying to read between the lines of the legal jargon and the political spin. And I've got to tell you, the more I dig into this, the more I realize that we are standing on the edge of a seismic shift in how we live our daily lives, especially when we travel. I've spent decades in aviation. I've studied the intricacies of U.S. transportation law until my eyes have bled, and I've watched the cultural landscape of this country morph in real time. But this is different. This isn't just a tweak to a regulation or a minor adjustment in TSA protocol. This feels like the ground itself is moving beneath our feet. I want to start with a question, and I don't ask this lightly, but I genuinely want to know where you stand because it's going to color everything I'm about to explain. If you walked into a grocery store tomorrow and realized that, legally, the default assumption had flipped, that now, unless a sign explicitly told you no, the assumption was that you could be standing next to someone carrying a concealed firearm. Would that change how you move through that store? Would it change how you feel about taking your kids to the mall, or even just pumping gas at a lonely truck stop at 2 a.m.? Drop a comment and let me know, because your answer tells me more about where you fall on this divide than any poll ever could. And trust me, by the time you finish hearing what I've uncovered about the Supreme Court's latest emergency ruling and the cases bubbling up behind it, you're going to understand why I'm asking that question with such urgency. This isn't abstract legal theory anymore. This is about to become the new reality of American public space, and the airport terminal, that great equalizer of American society, is going to be ground zero for the confusion. Let me rewind a bit for you, because we have to understand how we got here. For a long time, the world of gun rights and gun regulation existed in a kind of tense, localized equilibrium. New York had its rules, Texas had its rules, and generally speaking, if you wanted to carry a gun, you had to navigate a patchwork of permits and restricted areas. But everything changed, absolutely everything, back in 2022 with a case called New York State Rifle and Pistol Association versus Bruin. Now, I'm not going to bore you with a law school lecture, but if you travel, if you step outside your front door, you need to understand the monster that Bruin unleashed. The Supreme Court, in its majority opinion, basically threw out the old way of judging gun laws. Before Bruin, courts would usually ask, does a gun regulation serve a public good? Does it promote safety? Is it reasonable? But the Bruin decision said, stop. You can't ask that anymore. The only question a court is allowed to ask now is this regulation consistent with the historical tradition of firearm regulation in the United States? That means we have to look at laws from the 1700s and 1800s and see if there's a direct historical twin for whatever modern law is being challenged. If there isn't, the law is dead, unconstitutional, gone. I remember reading the decision when it came out and thinking, the lower courts are going to be absolutely buried. And they have been. The lawsuits exploded. Every gun law in the country became an open target. And because the Supreme Court has a solid 6-3 conservative majority that has shown a real appetite for expanding Second Amendment protections, the floodgates have opened. We saw it with challenges to bans on AR-15s, challenges to magazine limits, and now we're seeing it in two cases that are absolutely critical for anyone who ever leaves their house. Now, you might be looking at that title I gave this piece and thinking, gun permits are over? That sounds a little dramatic. And I hear you. But let me walk you through what just happened and what is about to happen, and you tell me if I'm being dramatic or if I'm just reading the writing on the wall. A few weeks ago, the Supreme Court heard oral arguments in a case that has been dubbed the Vampire Rules case. The actual name is Wolford versus Lopez, and it comes out of Hawaii. Now, I know what you're thinking. Hawaii? That's an island thousands of miles away. How does that affect me in Ohio or Florida? Bear with me, because this is the key that unlocks the whole puzzle. Hawaii, like several other Democrat-led states including New York, California, and Maryland, passed a law after the Bruin decision trying to figure out how to handle guns on private property that's open to the public. Think about it. A grocery store, a mall, a bank, a hotel lobby. These are private businesses, but they are open for anyone to walk into. Hawaii's law said that unless the property owner explicitly gave you permission, either by posting a sign or verbally telling you it was okay, you could not bring a concealed firearm onto that property. The default was no. You needed an invitation, hence the vampire rule nickname, because in the old stories, Dracula couldn't enter a home unless he was invited in. The state argued that this was a no-brainer. It respects the private property rights of the business owner. If a store owner doesn't want guns in their store, the state helps them enforce that. If they don't care, they stay silent, and the law keeps guns out anyway. It seemed like a compromise, right? Respecting the Second Amendment while also respecting the property owner's ancient, common law right to control what happens on their land. Well, the gun rights groups and the 3 residents from Maui who sued looked at it completely differently. They argued that by making the default rule a ban, the state had effectively created a near-total prohibition on public carry. Because, let's be real, how many of us are going to walk into a 7-Eleven and, before grabbing a soda, ask the clerk, "Excuse me, do I have your express permission to exercise my constitutional right today?" It's absurd. And because most businesses don't post signs either allowing or forbidding guns, you're basically trapped. You can carry your gun on the public sidewalk, but the moment you step into a store to buy a bottle of water, you're a criminal. The Trump administration stepped in, which is actually pretty unusual. They filed a brief urging the court to take the case and arguing that these state laws were an end run around the Bruin decision. They said exactly what the gun owners were saying. If you make every private business a no-go zone by default, you've functionally repealed the right to carry in public. When the case went in front of the justices in January, the atmosphere in that courtroom must have been electric. The conservative justices were not just skeptical, they sounded almost angry. Justice Samuel Alito cut right to the heart of it. He asked the state's lawyer a question that stopped me in my tracks. He said, essentially, would you accept a law that treated the First Amendment this way? Could a state pass a law saying that, by default, you are not allowed to speak freely on private property open to the public unless the owner specifically says you can? Of course not. So why, he asked, are you relegating the Second Amendment to second-class status? That phrase, second-class status, is going to haunt the lower courts for a generation. It tells you everything about how the majority of the court views these laws. They see them as tricks, as gimmicks designed to make a constitutional right disappear through 1,000 paper cuts. Now, here's where it gets even more intense. This case is still pending a final ruling, which is expected by late June. But the signals from the court are so strong that legal analysts are already writing the obituary for these permission slip laws. And if the court strikes down Hawaii's law, it doesn't just affect Hawaii. It guts similar laws in New York, California, New Jersey, and Maryland overnight. The default rule across huge swaths of the country will flip. Instead of no guns unless allowed, it will become guns allowed unless the owner explicitly says no. But wait, hold on, because there's another case weaving through the system right now that complicates this even further, and this is the one that actually scares me as a traveler. Just last week, the Supreme Court heard arguments in a case called Hemani versus Garland, which deals with a federal law that prohibits unlawful users of controlled substances from owning guns. Now, on its face, that might sound reasonable, right? We don't want people strung out on drugs carrying firearms. But the details of this case are a nightmare for anyone who's ever taken a CBD gummy to sleep on a long flight. The case involves a Texas man named Ali Hemani. During an FBI raid on his home, related to his travel to Iran, not initially a gun crime, agents found a Glock pistol, some marijuana, and some cocaine. Now, here's the kicker. Hemani admitted to being a regular marijuana user. He said he used it about every other day. But at the time of the search, he wasn't intoxicated. He was just a guy who happened to own a gun and happened to use a substance that is still federally illegal, even if it's legal in his state. The federal government charged him under that 1968 law. He fought it, and the Fifth Circuit Court of Appeals sided with him, throwing out the charge. They said, and I quote, "There is no historical justification for disarming a sober citizen not presently under an impairing influence." They looked back at history and found laws about disarming habitual drunkards, but they said that doesn't map onto a guy who smokes weed on his days off and is perfectly sober when he's handling his gun. The Biden administration, and now the Trump administration, since they're continuing the appeal, is arguing something different. They want the court to allow them to go after habitual users. They're trying to draw a line in the sand that says, if you use drugs regularly, even if you're not high at that moment, you're too dangerous to have a gun. Why does this matter for travel? Because imagine the TSA checkpoint. Imagine you're selected for additional screening. An officer goes through your bag and finds a legally registered handgun, unloaded, packed properly in a hard-sided case, declared at the ticket counter. You're doing everything right. But then, the officer also finds a pipe with a little residue in your carry-on. Or they find a vape cartridge. Or maybe they just get a hit on their system that flags you as a medical marijuana cardholder from a legal state. Under the current law, that could be a federal felony. You are an unlawful user, in possession of a firearm. And if the Supreme Court upholds this law in the Hemani case, or even if they just punt on it and leave the lower court chaos in place, we have a massive enforcement problem. Because the TSA doesn't enforce gun laws, they look for threats. But they do call local law enforcement. And that local cop now has a massive discretion call to make. Do they arrest you for being a stoner with a gun? Do they let you go? It depends entirely on where you are, the mood of the officer, and how the court rulings are shaking out that week. I remember sitting in a terminal in Denver a few years back, watching a guy get pulled out of line. He had a legal firearm. He had a Colorado medical marijuana card, and he was flying to Alabama. The look on his face when the police started asking him about his drug use was pure panic. He kept saying, "But it's legal here. I have a card." And the officer just shook his head and said, "Sir, federal law doesn't care about your state card." That guy walked away in handcuffs. That is the reality we are living in. So, on one hand, the Supreme Court seems poised to tell states, you can't ban guns from private property by default. On the other hand, they are wrestling with whether the federal government can ban guns from anyone who might occasionally light up a joint. The tension here is unbelievable. We are heading toward a world where your right to carry a gun could depend on your dietary choices 6 months ago, and where the places you can carry it could expand dramatically overnight. And let me tell you, the confusion this creates for the average person, especially the average traveler, is going to be catastrophic, because airports are a special kind of hell when it comes to this stuff. The laws overlap. You have federal law, state law, local ordinances, and airport authority rules all colliding in one crowded terminal. I've spent so much time in airports that I feel like I should have my own gate. And I can tell you, the number one thing people mess up, the absolute biggest mistake I see, is thinking that their permit to carry is a magical ticket that works everywhere. It's not, and it really doesn't work in an airport. Let's break down what actually happens when you try to travel with a gun, because it's not as simple as just throwing it in your suitcase and heading to the gate. First, you have to declare it. You walk up to the ticket counter, you tell the agent, "I need to declare a firearm." You have to open your bag, show them the unloaded gun in a hard-sided case, and show them that it's locked. You sign a declaration card. They put it inside the case, and it goes into the belly of the plane. That's the legal way. That's the only way. But the number of people who forget they have a gun in their backpack is astounding. They walk up to the TSA screening, put their bag on the belt, and the X-ray lights up like a Christmas tree. Suddenly, the whole security checkpoint freezes. The TSA officers back away, the police are called, and you are now in a world of trouble. And here's a warning that I don't think gets said loudly enough. Even if you declare it correctly, even if you do everything right, you still have to think about the laws at your destination and at any layovers. There was a bill analysis in Texas a while back that clarified what a secured area of an airport actually is. It includes the terminal building and adjacent aircraft parking areas. That means if you have a layover in Chicago and you pick up your checked bag because you're switching airlines and your gun is in that bag and you walk through the terminal with it, even if it's in the bag, unloaded, you could be in violation of local law depending on the state. Some states allow guns in the public areas of airports, some don't. Some, like New York, are incredibly restrictive. You have to know this stuff. The federal code is crystal clear that the TSA and airport operators have a mandate to screen and secure the area. They are supposed to keep weapons out of the sterile area. That's the law. But what happens when the sterile area ends and you're just in the check-in lobby? That's where the patchwork of state laws comes in. And that's where the Supreme Court cases are going to create a mess. Because if the court strikes down the vampire rules, then suddenly, in a state like New York, the default assumption in the public area of JFK Airport, the area before security, might be that you can carry a gun unless the Port Authority puts up a sign. Do you think they will? Probably. But what if they're slow about it? What if the signs are small? What if you're a traveler from Texas who is used to carrying everywhere, and you walk through that lobby to get to baggage claim? You could be creating an international incident without even knowing it. I want to take you inside the mind of a law enforcement officer for a second because I've talked to enough of them to know how they think. They don't like ambiguity. They like clear rules. If X happens, do Y. That's their training. When the Supreme Court creates ambiguity, when they flip the default rule on its head and say, actually, that law you've been enforcing for 3 years is now void, it puts the cop in a terrible spot. Imagine a police officer in the Honolulu airport next summer. He gets a call about a man with a gun in the baggage claim area. He shows up, and the man has a valid permit, and the gun is holstered. Under the old state law, that man would be committing a crime unless the airport had a sign up inviting guns. But if the Supreme Court strikes that law down, suddenly the man might be perfectly legal. The cop has to make a split-second decision based on a legal ruling he read about in the news that morning. Do you arrest him and let the courts sort it out? Or do you let him go and risk your career if you're wrong? That's the kind of chaos these sweeping rulings create. And this is where my experience as a traveler kicks in with a heavy dose of warning. You cannot rely on common sense or what usually happens. You have to become a student of the law. You have to check the regulations for every single state you set foot in, because the real-life consequences of getting it wrong are devastating. I've seen it happen. I watched a guy at the rental car return in Orlando get arrested because he had a firearm in his console. He had driven down from Georgia, where his permit was honored. He didn't realize that Florida, at the time, had different rules about vehicle carry. He was just returning the car, minding his own business, and a random security check by the rental company, who saw the gun, led to the police being called. He spent the night in jail and missed his flight home. His family had to drive back to Georgia without him, all because he didn't realize that the invisible line on the map changed everything. The Supreme Court is about to draw a lot of new invisible lines. They're about to tell us that our right to carry extends into the shopping mall by default. They're about to tell us that maybe, just maybe, a habitual drunkard law from 1805 doesn't apply to a guy who vapes CBD. And in doing so, they are handing the average American a tremendous amount of freedom, but also a tremendous amount of responsibility. And here's the part that really keeps me up at night: the airports themselves. These are federal facilities in many respects, but they're also leaseholds operated by local authorities. The security needs are immense. We are asking TSA agents, who are already overworked and underpaid, to now navigate a constitutional landscape that is shifting beneath their feet. We are asking them to distinguish between a lawful carrier and a potential threat based on a patchwork of rulings that change by the week. I remember reading the U.S. Code, Title 49, which governs air transportation security. It talks about the need for uniform procedures, the need for biometric credentials for law enforcement officers flying armed, the need to screen everyone entering a secured area. It's a massive, complicated machine designed to do one thing: keep planes from being hijacked. When you inject this level of legal uncertainty into that machine, you create friction, you create delays, you create opportunities for mistakes. And God forbid you are a lawful gun owner who also happens to be a dual citizen, like the man in the Hemani case. He had ties to Iran, which got the FBI's attention, and then they found the gun and the drugs. Suddenly, a simple trip to visit family becomes a federal case. The layers of scrutiny are just piling up. I want to be really clear about something, because I think it gets lost in the shouting matches. This isn't about whether guns are good or bad. This is about predictability. The entire system of travel, from the moment you buy a ticket to the moment you grab your bag at the carousel, is built on predictability. You need to know what to expect. When the Supreme Court changes the rules mid-game, they shatter that predictability. We are heading into a period of massive adjustment. If you are a gun owner who travels, you need to be more vigilant than ever. You need to assume that the laws you knew last month are now out of date. You need to check the local laws of your destination, your layover cities, and the airports themselves. You need to understand that a state permit is not a federal shield. And if you are not a gun owner, you need to understand that the person standing next to you in line at Starbucks in the terminal might now be legally carrying a concealed weapon in a place where they couldn't have 6 months ago. That might make you feel safer, or it might make you feel more anxious. But either way, it's the new reality we are building. The courts are moving fast. The emergency rulings are piling up. And the average person is standing in the middle of the intersection, trying to read their phone map, while the traffic lights, are all broken. I look at these two cases, the vampire rules case and the drug user case, and I see the Supreme Court trying to answer a question that maybe doesn't have a good answer. How do you apply an 18th century document to a 21st century world of airports, federal preemption, and medical marijuana cards? The answer they keep coming back to is, look at history. But history doesn't have airports. History doesn't have TSA checkpoints. History doesn't have a federal system where you can fly from a state where pot is legal to a state where it's a felony in 2 hours. So we are left to guess. We are left to interpret. And when we guess wrong, the consequences are life-altering. I think back to the oral arguments, and I keep hearing Justice Alito's voice in my head. Second-class status. That is the lens through which the majority is viewing any attempt to limit where guns can go. They see these state laws as insults, as efforts to undermine a fundamental right, and they are ready to strike them down. But in striking them down, they are creating a vacuum. They are saying to the states, you cannot set a default rule of no guns. But they are not, in this case, forcing private businesses to allow guns. They are just shifting the default. It puts the onus on the business owner to speak up. And that, my friends, is going to lead to a lot more signs. A lot more confrontation at the door of the grocery store. A lot more of that uncomfortable moment where you have to decide whether to go in or turn around. And for the traveler, it means every single trip requires a pre-flight checklist that goes beyond your passport and your tickets. It requires a legal audit. Where am I going? What are the carry laws there? What are the rules about private property? Does the mall I'm visiting have a policy? Does the hotel I'm staying at allow firearms in the lobby or only in the rooms? If I have a layover in a state with a duty to inform law, do I have to tell the cop who pulls me over for a broken taillight that I have a gun in the trunk? It's exhausting just to think about, but it's necessary because the courts have decided that this is the path we're on. They are tearing down the old restrictions, and it's going to take years, maybe a decade, for the new landscape to settle into something recognizable. In the meantime, we're all just navigating the rubble. We're reading the tea leaves of Supreme Court opinions, trying to figure out what a historical tradition of regulation means for a rideshare pickup zone at LAX. So I'm going to leave you with that question I started with, and I really hope you take a second to answer it in the comments. When the default rule flips, when the assumption becomes that guns are welcome until a sign says otherwise, how does that change your daily life? Does it change how you feel about taking your family to a theme park in Orlando? Does it change how you feel about that late-night flight home when you're waiting for a shuttle in a dark parking garage? I'm not here to tell you how to feel. I'm here to tell you what's coming. And what's coming is a complete upheaval of the rules we've all been playing by. The permits aren't dead, not exactly. But the power they gave you to carry in certain places, that landscape is about to be redrawn with a very heavy hand. Stay informed, stay careful, and for goodness sake, if you're traveling with a firearm, triple check everything. The margin for error just got a whole lot smaller.